my professional responsibility class, and we are going to talk about the most recent ABA formal ethics opinion, which is about ethical obligations of judges in collecting legal, financial obligations and other debts. And I'm going to start with a summary. This is ABA Ethics Opinion 490, and it was published on March 24th, 2020. It really didn't receive much media attention, obviously, because that was about 10 days into or 12 days into the national quarantine over the coronavirus epidemic. So this opinion addresses the ethical requirements of judges under the Model Code of Judicial Conduct, Rules 1.1 and 2.6, to undertake a meaningful inquiry into a litigant's ability to pay court fines, fees, restitution, other charges, bail, or civil debt before using incarceration as punishment for failure to pay, as inducement to pay or appear, or as a method of purging a financial obligation whenever state or federal law provides. And just to clarify for my students, the reason I'm doing this lecture is that the MPRE often includes one question on a recent ABA ethics opinion about judges. So one of the handful of questions, the 3 or 4 or 5 questions that are on the MPRE about judges and judicial conduct is often taken from a recent ethics opinion. So this is a quick overview to familiarize yourselves with the most recent one. This opinion also discusses some innovative guidance on best practices for making ability to pay inquiries, including model bench cards, methods of notice, and techniques for efficiently eliciting relevant financial information from litigants. And so here's the rules that the ABA says apply. And by the way, we don't really, part of what's going on here that's interesting, should be interesting for my students, is that the Code of Judicial Conduct does not head-on address this issue. And also, as some of my students know, bail reform is one of the hot issues in our legal system right now. And it's with a concern that indigent criminal defendants are given bail that they can't pay, and so they end up sitting in trial, and it's an access to justice issue. And so this is kind of one of the hot issues in our legal system. And in a sense, this is a hat tip towards that, or maybe even maybe using the judges as a kind of a backdoor form of bail reform, to use the ethical rules of judges. Okay, so 1.1, a judge shall comply with the law. 1.2, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. Rule 2.2, a judge shall uphold the law and shall perform all duties of judicial office fairly and impartially. Rule 2.5, a judge shall perform judicial and administrative duties competently and diligently, and shall cooperate with other judges and court officials in the administration of court business. And 2.6, a judge shall accord every person who has a legal interest in a proceeding or that person's lawyer right to be heard. Now, I want you to notice something. None of these provisions really square on address whether you can incarcerate someone because, lock someone up because they don't have enough money for bail or to pay a child support obligation or something like that. The other thing that's nice about this rule, and sorry for the cluttered slide, is that it gives my students just a quick look at 5 different provisions of the Code of Judicial Conduct. And as you can see, a lot of these are ambiguous enough. There's not really much to memorize here that would guide you in answering a multiple choice question on an exam. Also, 1.2, 2.2, and 2.5 of the Code of Judicial Conduct are proposed meaningful inquiry as a fundamental element of procedural justice necessary to maintain the integrity, impartiality, and fairness of the administration of justice and the public's faith in it. So according to the same rules, A judge may not set or impose or collect financial obligations under circumstances that give the judge an improper incentive, either to multiply legal financial obligations or fail to inquire into a litigant's ability to pay. And one of the concerns that, the most egregious concerns for the ABA, and there's been cases about this that have gone in the US Supreme Court, is judges who, let's say that they're part of the courthouse's budget is dependent on the fines that they collect. So, or there's horror stories from the past in our country of judges whose annual bonus or salary was partly a reflection of the fines that they assessed on their docket. Would you want to appear before a judge on your traffic violation who was going to get a cut of the fine that they assessed on you? And so the Supreme Court has held that that's a due process violation. And so decades ago in Bearden v. Georgia, a defendant, the court held that a defendant can't be incarcerated for a failure to pay, absent an opportunity to be heard on the question whether the failure to pay is willful, and whether bona fide efforts have been made to acquire the resources to pay, and whether there are alternatives to incarceration that would meet the state's interests. And just as a tiny bit of historical background, you may remember if you either enjoyed reading or were forced to read Dickens novels and Victorian era literature, that the UK had something called a poorhouse and could actually put people into in jail, debtor's prison, let's say. And it's part of our American legal tradition to kind of resent that and to push back against that. But legal realists have often pointed out that in effect we do that sometimes, where if you're indigent, you're way more likely to find yourself sitting in a jail cell, especially when you intersect with our criminal justice system. So formal opinion 490 also continues that more recently the Supreme Court has extended the Bearden framework for inquiry into ability to pay to contempt proceedings in civil debt collection cases that rely on incarceration to induce payment. And in other words, somebody is ordered to pay a certain debt, like child support, let's say, and they don't want to pay, so we're going to put them in jail if they don't pay, or they don't want to pay on a judgment, and so we're going to put them in jail if they don't pay. And before you do that, the Supreme Court thinks that you need to look into whether the person can pay, because we don't want to, we think it's wrong in this to incarcerate people just because they're poor, just for being indigent. Procedural irregularity regarding incarceration for failure to pay is therefore a serious breach of a judge's Rule 1.1 duty to comply with the law. And indeed, discipline has been imposed for procedural irregularity of this kind for decades as a violation of clearly established law, and in at least one jurisdiction, even years before Bearden was decided. And by the way, these my slides here are little snippets or excerpts from the ABA's ethics opinion. If you are wishing there were more details or wanted citations and footnotes, get ethics opinion 490, and it's going to give you everything you need. It's heavily footnoted and cited, and in my opinion, it's actually over-explained. They go into great detail, the ABA drafters, with a historical background for this. For my students, when we talk about procedural irregularity, we mean that the judges are fining people or demanding bail or sanctioning people, and then when the person can't pay, the judge, without further inquiry, just orders the person held in contempt and sometimes jailed. And then in other cases, of course, this is going to be inconsistently applied. If the person is wealthy enough or fortunate enough to afford a lawyer, the lawyer, they're more likely to get a hearing on things and to get some consideration and get to express themselves. Incarcerating pro se litigants for their inability to pay financial legal obligations without inquiry into their ability to pay directly undermines their opportunity to be heard on issues as to which they may most need accommodation. And the ABA concludes, finally, to the extent that courts do not have carefully prescribed procedures in place to prevent incarceration for failure to pay, and do not provide training to judges, court staff, prosecutors, and public defenders on proper procedures, the competent and diligent performance of judicial and administrative duties, as well as the cooperation with judges and so forth, required by 2.5 is compromised. And I just want to clarify again here for my students, what the ABA is trying to say is, first of all, the individual judge could be committing an ethical violation by incarcerating somebody for their inability to pay, for not paying something. What's happening is people aren't paying, and the judges are like, fine, go to jail until you pay your fine. But the person can't pay. And there's a difference between a person who can't pay and a person who can and is just refusing to. And similarly, they want the courthouses, the administrators of a local court, to have procedures in place and to train people so that we don't have bad apple judges or prosecutors or public defenders who don't really understand the need to protect the rights of the indigent population. So a judge's uncertainty regarding whether inquiry into a litigant's ability to pay in a particular circumstance is necessary under binding precedent, and it should be resolved in favor of making the inquiry. In other words, if you're a judge and you're not sure what to do, here's a rule for you that I wish they could have spelled this out clearer, so I'm going to tell my students. If you wanted to make this a clearer rule, the rule is, when in doubt, give the person a hearing. When in doubt, hold a hearing about their financial situation before you incarcerate them or even threaten them with incarceration. Where a litigant is unrepresented or the matter is civil, doubts about ability to pay and the willfulness of a litigant's failure to pay and the bona fide efforts of a litigant to secure the means to pay and the viability of alternatives to incarceration should generally be resolved against incarceration in the absence of circumstances indicating that the litigant poses a threat to public safety. And in case my students haven't heard this, there's a big concern in our country about our mass incarceration, that we incarcerate a really inconceivable percentage of our population. And it seems like it just gets worse and worse. Our prisons are crowded. And part of this, a lot of this is over, as you know, things like petty drug offenses and things like that, that have allowed for kind of mass incarceration. And it's a problem. And then on top of that, we're incarcerating people sometimes, putting them in either a county jail or a regular prison, and essentially it's functioning as a debtor's prison system merely because the judges aren't giving people enough process. Judges also have to avoid conflicts of interest, and this should be kind of obvious, I think, to a law student, that arise from setting or imposing or enforcing legal financial obligations to fund the court on terms that give judges a direct incentive either to increase these obligations or to avoid inquiring into ability to pay. Now, on this slide, I have a picture of what it looks like a very well-funded courthouse. And but I want you to think of a small rural district or county or something like that, where they are strapped for funds and have trouble. The judges and staff are not well paid compared to their counterparts, let's say in big cities or affluent areas of the country. And we end up with systems where judges have some sort of direct incentive to fine people more as a source of revenue for the court, or at least to give people extra hearings to let them out of their obligations to pay. Again, we're not talking about telling people they don't have to pay, and I want to make sure you understand that. We're not telling people that we can't order people to pay a court judgment, to pay child support, or things like that. The problem is that then when we set that amount and we don't look into whether they actually can pay. So courts need to have policies and practices and procedures so they can efficiently and accurately determine a litigant's ability to pay, They need to divide administrative tasks to guard against even the appearance of impropriety in the setting and enforcement of legal obligations. We don't want any party to ever think that the judge is kind of harsh with fines, levying fines on people and sanctions on people because the judge has skin in the game. We don't want judges who have skin in the game. And to provide training to judges and court staff and prosecutors and defense attorneys. Here's our conclusion. The liberty interest protected by the duty to inquire into the ability to pay prior to incarceration for failure to pay are fundamental to litigants' rights and to the rule of law itself. Courts have an ethical duty not only to comply with the law insofar as it requires inquiry into ability to pay, but to protect the integrity, fairness, and impartiality of the judicial process by ensuring that compliance is robust and consistent with legitimate state interests and public safety. Okay, this concludes our lecture on ABA Formal Ethics Opinion 490 about a judge's ethical duty to inquire into people's ability to pay, litigants' ability to pay before punishing them with incarceration or even threatening to incarcerate them.